a very warm welcome to thorough newspaper analysis for the 3rd of April 2024. Now let's quickly proceed and have a look at the discussion pointers for today. So first of all, we have the editorial segment. Here we've taken up an Indian Express article with the title, Why the Supreme Court Barred Unregulated Soil Extraction for Linear Projects. See, there was a notification by the central government wherein it categorically stated that for the construction of any linear project, now what is a linear project that we'll understand later, but it stated that for construction of a linear project, soil can be extracted without seeking any environment clearance. So the matter reached the NGT. NGT asked the government or the ministry concerned to do something, but the ministry did not act in the manner which NGT wanted it to. As a result, the matter was before the Supreme Court. Now, the Supreme Court has come forward and made certain observations with respect to that notification and the exemption. So that is going to be the core of discussion for today. Secondly, we talk about the important news updates, and this is going to be followed by the last segment where we have a look at the legal news. So without further ado, let's start with the article and let's first see the context of it. So very recently, the Supreme Court set aside a notification which was issued by the Environment Ministry about 3 years ago. Now, this notification, it exempted the extraction of ordinary earth. What is ordinary earth? Soil. So this notification exempted the extraction of soil for linear projects such as the construction of railways and roads from obtaining environmental clearance. The exemption offered in March of 2020, it was challenged before the NGT, which is National Green Tribunal, which asked the ministry in October of 2020 to review it within a period of 3 months. Now, because the ministry did not act upon this order of the NGT, the matter reached the Honorable Supreme Court. The Supreme Court very recently, which is on 21st of March, struck this notification down by saying that this exemption, it was blanket, it was arbitrary, and therefore it is a violation of Article 14 of the Indian Constitution. Now let's quickly see how this notification came about. What is the center's reasoning justifying it? So for that, we go back to September of 2006. In September 2006, the Environment Ministry had issued a notification under the Act of Environment Protection Act 1986. Under the 2006 notification, it specified certain activities that would require prior environmental clearance. But then, 10 years later, in Jain of 2016, a second notification was issued wherein exemption was granted to certain activities or certain categories of projects from the requirement of obtaining the environment clearance. So therefore, the seed for exempting certain activities from seeking environment clearance, it was sown for the first time almost a decade ago, which is in 2016. Later in March of 2020, a third notification in this series was released, which added this particular to the list of exempted activities. Now, what was added? I would like to read that out. It is extraction or sourcing or borrowing of ordinary earth for the linear projects such as roads, pipelines, etc. So now let's quickly head ahead. Let's quickly go ahead and have a look at how the center has justified this particular notification and exemption. So the center essentially has argued before the NGT that this exemption, it was very much needed for the aid of general public, and that it is going to help the potters, the farmers, the gram panchayats, banjaras, outs of Gujarat, and all non-mining activities which are identified by these states. The central government also said that the grant of this sort of an exemption, it is within the realm of public policy. It is within the realm of policy matter, and therefore we, the government, the state, is the right body for making a decision in this regard, and the judiciary as a forum should not intervene. Lastly, the central government argued that there was an amendment which was brought about in 2020 March in the act which is called the Mines and Minerals Development and Regulation Act of 1957. Now, because of this amendment, this was allowed. Now, what was allowed? By virtue of this amendment, it was said that, let's say there is an ex person, he took a mining property on lease, and thereafter he obtained the requisite licenses, the permissions needed for carrying out the mining activity. And thereafter, the person X leases property to, let's say, XYZ entity, other Y or Z entity. Now that entity becomes a new lessee. This new lessee will have a right to continue mining for a period of 2 years. So the central government was essentially saying that because we amended the 1957 law, therefore we wanted to bring the notification in conformity, the 2016 notification in conformity with the amendment, and as a result, we brought this exemption. Now let's have a look at the grounds for challenge. The exemption was challenged before the NGT on the broad ground that allowing extraction of soil indiscriminately, it was arbitrary and therefore violative of Article 14 of the Indian Constitution. Further, the petitioners argued that the exemption, it violated the requirement of prior environmental clearance in leases as laid down by the top court in the matter of Deepak Kumar versus the state of Haryana. This goes back to 2012. Another contention by the petitioner was essentially that the motive or the agenda of the ministry and the central government was something else, and the government was just playing under the garb of public interest. See, it was argued that the ministry circumvented the legal process of inviting public objections before issuing this notification by wrongly exercising its powers to do away with such requirements under the garb of public interest during the COVID-19 pandemic to serve and further the interest of the private miners and contractors. So essentially, the petitioners were saying that, under the garb of public interest, the government merely acted in a way which furthers and advances the interest of the private stakeholders in this business. That is to say, the private miners or the private contractors. And as a result, in October of 2020, NGT said the ministry should strike a balance. And instead of giving, a blanket exemption, there should be certain appropriate safeguards in place about the process of excavation and the quantum of the excavation. The tribunal, it therefore asked the center that it revisit this notification in a time-bound manner. So now let's see, what did the government do? Did the government act in a time-bound manner in accordance with the NGT order? So see, the center, it sat on the NGT order until the appellant moved the Supreme Court. It was only after the Supreme Court concluded the hearing and reserved its judgment on August 10th last year that the ministry issued an office memo on 21st of August. In this office memo, the ministry laid down the enforcement mechanism for the exemption. On 30th of August 2023, the ministry notified that the exemption was subject to compliance of SOPs. That is to say, it was subject to compliance of the standard operating procedures and environmental safeguards, which is issued in this regard from time to time. So now, having understood the rationality that the government, put forth, justifying this notification, and having understood the challenge and the ground of challenge, now let's see how the Supreme Court has appreciated all of these grounds and what the Supreme Court has to say in this matter. So first and foremost, it was held by the top court that this notification, it was completely misguided. It was blanket exemption. It was arbitrary and violative of Article 14. Why? Because this notification did not define linear projects, nor did it specify the quantum and the extraction area. It is also not provided that only that quantity of ordinary earth which is required to implement the linear projects is exempted, the court said. Please note, the court noted that, let's see, there is a certain project which is going on, and for that, X amount of soil is to be extracted. This notification nowhere specifies that you just extract the X amount of soil which is needed for the project without environmental clearance. There is no upper cap, there is no limit whatsoever on the quantity which is specified. And therefore, the Supreme Court said that the exemption was granted without incorporating any safeguards, which defeats the purpose of the Environment Protection Act. Secondly, the court held that the ministry offered no justification whatsoever for concluding that in the public interest, the requirement of public notice should be dispensed with at any stage, be it in the notification or in the center's response before the NGT or before the Supreme Court. The decision, it was made without any application of mind, the Honorable Supreme Court added. Thirdly, it was stated by the Supreme Court that the August 2023 notification, which was, released following the issuance of the office memo, it also failed to elaborate on the concept of what a linear project is. It did not specify the authority responsible for the environmental safeguards or the provisions which are needed for environmental safeguards, nor did it impose any restriction whatsoever on the quantum of extraction. And thus, the court said, the notification was issued 2 days after the nationwide lockdown was imposed. The work of linear projects such as roads, pipelines, etc., had come to a grinding halt. Therefore, we fail to understand the undue haste which was shown by the central government in issuing the impugned notification. So I hope this entire topic, this issue of unregulated soil extraction is clear to all of us. And now we proceed to the next segment.
So now let's proceed to the national news category news updates. And the first being this one. China renames 30 places in Arunachal Pradesh. So this is the fourth attempt whereby China has unilaterally renamed places in Arunachal Pradesh. Earlier, China has done that thrice. Once in 2017, then 2021, 2023. China renamed 30 places along the line of actual control in India's northwestern state. Please remember, Arunachal Pradesh is the northwestern state of India. The list of the places which are renamed by China, these include 11 residential areas, 12 mountains, 4 rivers, 1 lake, and 1 mountain pass and a piece of land. Next up is this update. The Reserve Bank of India, it is to set up Digital India Trust Agency to check illegal lending apps. The RBI is considering establishing Digita, that is Digital India Trust Agency, to stop the mushrooming or the development of illegal lending apps. The proposed agency will enable verification of digital lending apps and maintain a digital register or a public register of verified apps. So apps, those are not carrying this verified signature of Digita, they should be considered unauthorized for the purpose of law enforcement. Just a moment, give me a moment. I'm trying to switch to the next slide. Okay. Next up is an update in the sports category. Indian tennis star Rohan Bunappa, he has created history. Why? Because he, along with his partner Matthew Ebden, they've defeated Croatia's Ivan Dodig and American Austin Krajicek to clinch the Miami Open title. In the process, Bunappa, who is aged 44, he has become the oldest man to win a Masters 1000 title on the ATP circuit. Also, the Miami Open win, it enabled Bunappa to become the second Indian since Leander Pace to reach the final of all 9 ATP Masters 1000 events. So for your exams, what you need to remember is the pair who has won this particular title, which is Rohan Bunappa along with his partner Matthew Ebden. Next up is an update about the Odisha Foundation Day. Here you have to note down a couple of things. One is when is the foundation day, when was the state carved out. That's it. That should be sufficient for your exam purposes. So the Odisha Day, also called the Utkala Divasa, it is celebrated on 1st of April in the Indian state of Odisha in memory of the formation of the state as a separate state. Now, out of which states or territories was Odisha carved out? So please note, it was formed as a separate state out of Bihar and Orissa province with addition of Koraput district and Ganjam district from Madras presidency, and this happened on 1st of April, hence the celebration on 1st of April. And in what year? That is to be remembered. So it is in 1936. Next up is an update in the category of awards. Vijay Jain, he has secured or bagged Times Power Icon 2024 award. Vijay Jain, who is the managing director of Star Estate, he was awarded the prestigious Times Power Icon 2024 award. This is done in acknowledgement of his achievements in the real estate sector. India, it is the government of India, it has started a new scheme to promote electric vehicles in India. Now, this is implemented by Ministry of Heavy Industries. So please note down this particular scheme, the feature of which we'll just discuss. It was launched by the Indian government and it is to promote electric vehicles in India. And the concerned ministry here is Ministry of Heavy Industries. So India initiated the Electric Mobility Promotion Scheme 2024 to advance the adoption of electric vehicles. With a focus on boosting domestic manufacturing and enhancing EV supply, the scheme, it aims to support nearly 372,215 electric vehicles by July 21st of this year. Now, this has brought us to the legal news category, and the first update is from Honorable High Court of Allahabad. So, the High Court has said that suit for declaration of civil death, it is not barred by Section 34 of the SRA, merely because further relief wasn't claimed. The Allahabad High Court has categorically ruled that a suit for mere declaration of civil death, it is maintainable and it is not barred by virtue of Section 34 of the SRA, merely on the ground that the plaintiff did not claim further relief. The bench further noted that there is no bar under Section 34 for filing a suit for declaration of civil death of another person if the plaintiff is a legal heir of such person and such legal character of civil death, it is for the benefit of the plaintiff and the same is attributed to such legal character. Justifying the plaintiff being the legal heir here, the Supreme Court further noted that declaring a person's civil death is a substantial relief and therefore it has immediate consequential effect. So on the declaration of a death of a person, benefits are accrued on the legal heirs of the person who is declared as death. Therefore, relief of all such benefits cannot be sought vaguely in the garbs of further relief. The name of this particular case is Raisa Banu versus Shrimati Tabassum Jahan and others. Next up is an update from the Honorable High Court of Delhi. Here, the Delhi High Court has said that the onus to establish employee-employer relationship, it rests on the claimant. So, a single judge bench of the High Court, it has recently reiterated, that is to say, it has re-established a position of law which is indeed settled by saying that the onus of establishing the relationship of employee and employer between the management and the workman, it is on the claimant. That is, the person who sets up a plea of existence of such relationship between the parties. So essentially, the court is saying that if any person is coming forward before the court and saying that a relationship of employer and employee exists between him and the other party, then the onus of establishing this factum of existence of the relationship, it is on that person alone. For that purpose, the court made reference to both of these decisions. One is Kanpur Electricity Supply Company Limited versus Shamim Mirza, and the other one is Baburam versus Government and City of Delhi. The court further was of the view that as per the settled position of law, the claimant must prove the existence of the employee-employer relationship by way of either direct evidence and or through circumstantial evidence of incidental or ancillary nature, which the petitioner failed to do, the court noted in this particular case. The name of this case was Sunil Kumar and others versus the state and others. So with this, we come to an end of our TNA. In case you want to get access to the free study materials that we curate or the TNA slides that have been used in this video, I would highly encourage all of you to join our Telegram channel for the same. Do so, you can click on the link which is given in the description, or you may scan the barcode here. Now, these are the point of contacts in case you want to get in touch with LawSikho. Thank you so much for being with us and have a wonderful day ahead.